Thank. Did you ever reach out to the defendant while you were on vacation? Since the final text message.
Sorry, I just want to make sure I heard that.
Did you ever try to reach out to the defendant while they were on vacation? She said no.
Thank you.
Ever reach out to the defendant while you were on vacation? She said no. That answer, short, certain, delivered without hesitation, would come back to define this entire trial. People versus Michael Clark. Stalking in a domestic relationship.
Thursday.
Thank. Did you ever reach out to the defendant while you were on vacation? Since the final text message.
Sorry, I just want to make sure I heard that.
Did you ever try to reach out to the defendant while they were on vacation? She said no.
Thank you.
14A District Court, Washington County, Michigan. The people called 2 witnesses. The defense called none. And by the time the cross-examination was finished, the prosecution's case had been taken apart piece by piece. Using the witnesses' own words, Michael Clark and Payton Tropha worked together at a Pittsfield Township ambulance company. They had been romantically involved. When that relationship ended in early February of 2026, Clark sent messages he showed up at work. He left coffee in her locker. And Payton reported it to police on February 22nd, 11 days after the last incident she described. The prosecution's theory was straightforward. Been told to stop contacting her, he continued anyway. On February 11th, he followed her into a parking lot at night. She was afraid. That fear was the heart of the stalking.
Your Honor, some of these facts are not going to be contested. Some of the proofs are going to be pretty consistent, but there's going to be a general theme we think that the evidence will lead you to of a highly embellished presentation of allegations. This goes from the stalking charge to the DV as well. One of the things that you're going to hear, Your Honor, is when Mr. Cook said there was a relatively short dating relationship.
Stalking charge. Defense. Nicholas Buckage had a different theory entirely. He told the court in opening statements that what happened here was not criminal behavior. It was a breakup, a bad one, set off by a third party's lie. Lasted exactly 1 week of any real disputed contact. He promised the evidence would show embellishment.
We're going to present evidence that's exactly false, that my client didn't do that. Ms. Tropha did it. Ms. Tropha switched the schedules. She told the police 2 things about that. She said, number 1, he did that. And number 2, he did that before we started dating. And number 3, I think I said 2 things. Number 3, she couldn't do it. She didn't have the status that she described herself as a D-lister. Well, we're going to refute all 3 things. She made the switch. She had the ability to do it by using friendships.
Systematic, calculated embellishment. Starting from the very first conversation Payton had with police. The prosecution called Payton Tropha first. On direct examination, she told the court the relationship lasted about a month, that Clark had repeatedly contacted her after she told him to stop, and that on February 11th, he followed her through the parking lot in a way that made her fear for
the defendant moving. Was it a walk, a run?
It was to me in the moment, it seemed like a steep walk kind of towards me.
And you said
her safety. She described the moment he approached her ambulance as
in here you text, quote, "I'm shaking and he won't leave me alone." Was that true? Were you shaking at the time? Why were you shaking?
I was nervous because I did not want to talk to him and he wouldn't leave me.
Her words, a speed walk toward her. She texted her supervisor that night, "I'm shaking and he won't leave me alone." Then the cross-examination began. Buckage started at the end and worked backward. He asked Payton whether she had contacted Clark on the night of February 22nd, the same night she filed her police report. She said no. He asked again. Her phone contacted his phone at 10:43 that night. Was that her? She said she had checked her logs. It wasn't there. He asked who told her to check her logs. She said she had heard from other people that Clark was saying she called him. Showed her a screenshot of the incoming call on Clark's phone. Her number. 10:43 p.m. Do you admit making that call? She said she didn't know how that happened. He moved on. During vacation, she had told the prosecutor she had not contacted Clark. Buckage asked her to confirm that directly. She confirmed it. Then he asked whether she had grabbed her friend's phone, identified herself as Payton, and sent Clark 2 text messages. She said she didn't remember sending 2. She remembered sending 1. Contact.
You had told Mr. Cook on direct examination, and you had told Judge Simpson that you did not communicate with my client on vacation. I asked you to repeat that just now as a predicate to the next question, and you confirmed that's true. So then the question was, isn't it true that you grabbed your friend's phone and said, texted Mr. Clark, this is Payton, and texted him 2 text messages?
2 text messages, I do not remember. I do remember sending him one saying to stop contacting me.
So you actually did communicate with him, correct?
Her. So you actually did communicate with him, correct? Yeah, that was the first crack. But Buckage wasn't finished. He turned to the relationship itself. Payton had told police the relationship lasted less than a month. She said it to them spontaneously, unprompted, multiple times. Buckage asked if she was aware she had done that. She was. He then walked through the timeline. September, when Clark started staying at her place during long shifts to avoid the commute to Hillsdale. October, asked him to stay in her room with her for comfort after a previous relationship ended. November, when the arrangement became exclusive. Thanksgiving together, Chris together. And on December 19th, when a coworker at Barnes & Noble asked her directly, "You're Clark's girlfriend?" She said yes. So from early November through February 5th, sexually and romantically, true or false? After a pause and a few attempts to...
Now, when you spoke to the police on the 22nd of February, you were mindful to volunteer that piece of information repeatedly. Here's what I mean specifically. We're only together less than a month. It was less than a month. You said that to them 2, 3, 4 times. Would you agree? You said that to them kind of spontaneously, right? I mean, like just a filler to kind of document why Mr. Clark was reacting the way he was about the breakup. Would you agree with that? Like, oh, hey, look how bizarre he's being. We were only together less than a month.
I guess you could say that, yeah.
To distinguish between dating and being together, she confirmed it. She had told the police less than 1 month. The relationship had been running for over 3. Buckage then addressed the shift schedule. Payton had told police that Clark had maneuvered himself onto her shift before they started dating. In what she described as creepy behavior, she said she was a D-lister who had no control over such things. Asked her to review a series of text messages from November 10th, 2025. You caused the shift, didn't you? You asked a friend of yours to switch so you could be on the same shift with Michael.
For to switch, that was not, it had nothing to do with me. I gave her Barney's number, if they wanted to switch it.
You asked her to do it.
I asked her if she would at the time, but I didn't ask her, I have no control over it.
You have no control that she would do it, but you desired it and you asked her to do it, right?
I asked her according on his behalf. Yes.
You bragged to him, look, people love me, I got it done, right?
I said, I have a little pull with people. Some people like me, I don't. Yes.
I have a little pull, meaning I got it done. You, the D-lister. He didn't control this. Well, if he did, why did he need your help? Didn't he say in that same exchange that
which was the other person.
You made the police think that he had authority to do it as a C-list.
I told them that he was able to switch on to my shift, that they have no control of that.
You wanted to be on the same shift, didn't you, ma'am?
Yes.
Because you were romantically involved, yes? And you enjoyed being together.
I asked her if she would at the time. You bragged to him, "Look, I got it done, right?" She said, "I have a little pull with people who like me." She had told police he did it before they started dating, and that she had no power to stop it. The text showed she arranged it herself while they were already involved and celebrated getting it done. Now Buckage arrived at the locker. "I'm scared." Payton had testified that finding coffee and a note in her locker on February 11th made her feel overwhelmed and diminished. The prosecution had used this as evidence of unwanted contact at the workplace. Buckage asked whether she had ever left anything in Clark's locker. She said no. Then she walked it back. She had brought something to the lunchroom from his locker. He showed her text messages from February 4th.
They're dated February the 4th, 2026, is that right? And they end with you leaving a present in his locker, right? And you did leave. You said, just as you testified that Mr. Clark said coffee in your locker, you testified to him, or texted to him on February 4th, present in your locker, yes? And you left a present in his locker.
He was actually in the lunchroom, and I had taken it back to coffee and breakfast, and I had actually brought it into a lunchroom.
From his locker? That's where you left it for him to find. Okay.
The day before the breakup, where she told Clark she had left a present in his locker. "You left a present in his locker." She confirmed it. That was a clean, quiet reversal. No dramatic music needed. Then came the biohazard sticker. Sometime in April of 2026, while the case was pending, someone had placed a sticker on Clark's workplace locker. The sticker was not a blank label. It had been filled in with specific case information, the full case number, including trial court date of April 20th, 26th, the date of the complaint itself, and Clark's high school nickname Tobis. Buckage asked Payton whether she had ever seen the sticker. He then asked her, before showing her anything, whether she was aware of the case number, down to the SN designation. She said yes. Whether she was aware the trial date of April 20th was on it. She said yes. Whether the nickname Tobis appeared on it. She said yes. Then Buckage paused and said it directly. "I've not shown..."
Information. Would you agree? Tell me if I'm right or wrong. It had the case number. You didn't supply the case number of this case to anyone? Right down to the digit of what we call the case codes, the SM at the end. It had the next pretrial date. April 20th, 2026. Would you agree?
Yes.
Seem to know a lot about what's on that sticker, but we'll come back to that. And you didn't tell anyone at work what the next court date was?
Other than the witnesses?
Well, you didn't know who the witnesses were in April of 2026, did you?
Witness sections of what he had done.
No, I'm talking about in putting the sticker on the...
I was not actively out.
Who did you provide April 20th, 2026 to?
Other than the people that were here, nobody else.
What about that year when?
When we had the pre-trial, I had a Kindle with the meeting and all. They didn't know that James was because they were.
So, are you familiar with the nickname Tobis?
Yes.
Whose nickname is that? And on that sticker was the name Tobis. Would you agree? I've not shown you a picture of the sticker, but you've just verified everything that's on it. How did you become acquainted with it?
I've shown you a picture of the sticker, but you've just verified everything that's on it. She said her supervisor had told her what was on it, During questioning, Buckage pressed that point. She had said she was questioned by HR about the sticker, but that no one showed it to her. She said her supervisor described it verbally. No photograph, no physical sticker, just a description. The court had its own difficulty extracting a straight answer. Who had provided her the information, and when kept shifting. At one point, Payton said she was never contacted by HR about the sticker at all. Then she said she had spoken to her supervisor, Dave. Then she said she had never been formally questioned. The timeline moved each time.
Oh, hold on. I thought you said you had to talk with HR about the sticker.
I talked to my supervisor about the sticker.
Did I mishear that?
I don't think you did, but now you've invited another thought of questions. So,
Did you talk, so we're clear, did you talk with anybody from HR or HVA management about that sticker?
Yes.
Who did you talk to?
My supervisor, Dave.
What day did you talk to Dave?
Dick was in visiting, like some locker. He had came and asked me about it. I do not know what day it was placed.
But it was, correct me if I'm wrong, because it was the day after the pretrial date, where the date set was April 20th.
A question closed in on a specific date. By the time cross-examination wrapped, the picture Buckage had painted looked like this. A relationship described as less than a month had lasted 3 times longer. Shifts described as manipulated by Clark had been arranged by Payton. Gifts described as sent after the breakup had been ordered before it, and Clark had told her directly they were coming. A chase described to police as running had become a speed walk in court. An approach on February 7th, described to police as a chase to her car, had turned out, by her own testimony, to be Clark walking up and knocking on her window while she was already seated inside, and she had called him the same night she filed the report. The prosecution's second witness was Angel Lewis, Payton's roommate. I'm scared, who had been in the parking lot on the night of February 11th. Lewis testified that she saw Payton pull up in the ambulance and then run toward the building door, with Clark running after her at a full sprint. Reaching his hand out as she went through the door, the judge asked Lewis directly how far away Clark had been from the ambulance when she first spotted him. 5 to 10 feet.
Payton pulls up in an ambulance to one of the garage doors. And you see her do that? Okay. And at the point you see her do that, where is the defendant?
I hadn't seen him at that moment. She got out of the truck, and that's when the line of road trucks that we are that came up.
And how long did you him for? How far from the point at which you see him to the truck that Payton's in, how long a distance is that?
Maybe 5 to 10 feet.
Then showed her surveillance video from that night. She watched it. She confirmed the ambulance, confirmed the general time frame. Buckage asked her whether, based on what she saw in the video, the individual approaching the ambulance looked like he was running at full speed. She said she would agree he was not necessarily a fast walk. They're just walking across with that.
Right. Would you agree?
I would agree.
In fact, not even necessarily a fast walk. They're actually just walking across. Agree with that? Yes? All right, go ahead, Mr. Simon.
Your Honor, I can play some additional
snippet of that video. It's fractured, unfortunately. That could tie this up. But I will admit, as I showed to Mr. Cook, there's a 30-second gap that is unaccounted for.
Yes. The judge then asked Lewis to clarify exactly when the running she had described actually happened. Lewis said it occurred after the ambulance stopped, specifically at the point when Payton was already halfway through the building door. Buckage noted the video had a 30-second gap at that precise moment.
The running that you saw, when did that happen in relation to the video?
It started as soon as it was going towards inside the door.
And perhaps if we need to, we can put the video back up. After the vehicle comes, well, I don't know if I'll need it just yet, but after the vehicle comes back around, comes to a stop, were you able to see Payton at any point at that point? In the video, were you able to see her? Right. And so it's after then that you're saying is when you saw the running?
I guess I'm trying to figure out when this running, this full sprint was. I see in the video, we see the ambulance basically come toward the camera, correct? An individual then approaches that from this court's perspective looks like Mr. Clark, right, from my observation. And at some point, they're along the side of that ambulance, right? Is it from that point that the sprint happens?
One Payton is outside of the ambulance door and halfway in the garage door to the side that's not the actual garage door.
That gap was unaccounted for. After both prosecution witnesses testified, the defense moved for a directed verdict. Buckage argued the people had not come close to proving the elements of stalking beyond a reasonable doubt. The judge acknowledged the motion but denied it, saying that while it was barely there, a reasonable fact finder could still make the finding based on the text messages and testimony.
Slim, I think a reasonable fact finder, were they to believe certain things, could conclude that the offense of stalking, barely, you meant that, but barely, could make that finding regarding stalking, for the reasons as stated by the people. And so for those reasons, they will deny the motion.
Testimony viewed in the light most favorable to the prosecution. Trial moved to closing arguments. The prosecution focused on the text messages. February 5th, Payton said she couldn't do this. February 9th, she told him again she did not want to talk and did not want any further contact. February 11th, Clark acknowledged in a text that he knew she would not reply. The people argued that pattern showed awareness that his contact was unwanted and that he continued anyway. Defense closing was brief. Buckage pointed back to something the prosecutor had left out. On February 9th, Payton had also written to Clark.
The problem is that that's cherry picking. Mr. Cook was reading those February 9th messages and then he left this part out. When I said you could try and I wouldn't, that meant I'm trying not to reconcile this, and no matter what you do from now, there will be no second chances. And that string ended with, I did not understand that's what you meant by you could try.
You can continue to fight for this. Had said he didn't understand that phrase meant no more contact. Argued that everything from February 5th through the 9th, and in exchange, Clark unleashed in part as Payton leaving the door open. The lone text on February 10th and the events of February 11th were what remained, and he argued that fell well short of a willful course of conduct designed to harass. Then the judge spoke. He said he had listened closely to all of it. I'm scared. He said the real question was whether he believed, based on everything he heard, that the defendant had actually been stalking Payton. He said he did not believe that was what the evidence showed. He addressed the embellishments directly. He said it was not until the process of cross-examination that both Payton and Lewis were called to account for what they had actually said. He noted the relationship length, the gift narrative, the shift schedule, and the sticker. He said he did not believe for one moment. I'm scared that either witness had been questioned by supervisors about an item they had never seen. He said Payton came before the court and lied. Said
That two people got called into HR, four supervisors, questioned about an item that they've never seen. That makes absolutely no sense. And I don't even know how they could then speak on it. But then you listen to Payton, and she's going through each of the things that are on it of something that she has never seen, been questioned about, but has never seen. Do I believe that? Absolutely not. I think she came before this court. I think she lied. I think Miss Lewis was complicit in that lie. And
Lewis was complicit in that lie. He said what had actually happened was a breakup set off by a false accusation from a third party. Scared, that devolved into a series of events that were then embellished to look like something they were not. Said attempting to recover your property while arranging a pickup time is not stalking. Trying to clear your name after being falsely accused of cheating is not stalking. He said a broken heart, no matter, without the intent and the threat that the statute actually requires. And then he said it plainly. For those reasons, the court would find that the defendant is not guilty of this charge.
frankly, in this court's mind, the major elements of stalking. So for those reasons, the court would find that the defendant is not guilty of this charge. The defendant is further released and discharged from any further obligation to this court. Thank you.
And first retrieve the exhibits.
Michael Clark was released and discharged from any further obligation to the court.